Good morning, good afternoon. Welcome to this session brought to you by the ASAE Technology Section Council. Our session today is called GDPR Overview and Implementation Recommendations for U.S.-based nonprofits and associations. My name is Todd Tolbert, and I'm the Chief Digital Strategy Officer at ASIS International and the Vice Chair of the ASAE Technology Section Council for 2020. First, we'll do a little housekeeping. Please make sure to mute yourself when not speaking. We want to make sure everybody can hear both the presenters and any questions, discussions that might happen. And please don't be offended if we mute you from this end. If you have a question, please ask your question in the chat and we'll get it in the queue for our presenters during the presentation. Today, our experts are going to bring you a very cool set of perspectives on this topic. Let me introduce you to them first, and then we'll talk about how we're going to go about doing this. So first, Wendy Salih is Director of Technology at Regulatory Affairs Professional Society. Wendy has 19 years as a technology leader in nonprofit, specializing in strategic technology overhauls and implementations. As a web developer in the 90s, she created one of the first online project management applications. She was recently published in CIO Review magazine and is a current member of ASAE's Technology Section Council. She has also successfully implemented system-wide GDPR policies and procedures for the Regulatory Affairs Professional Society. Dorothy Deng is a partner at the law firm Whiteford, Taylor & Preston, LLP. She is a member of the firm's nonprofit and association section. She assists nonprofit organizations and associations on a variety of legal issues, including governance, intellectual property, social media, privacy, and international operations. She served on ASAE's International Section Council from 2015 to 2017, and for 2020 is a new member of the ASAE Tech Council. Her publications include How Associations Can Protect Their Content Rights Before Going Global, China's Overseas NGO Law, Next Steps for Associations, and Guidelines on the Territorial Scope of GDPR, 5 takeaways for US-based associations and nonprofit organizations. So welcome to both of you all for this session today. So as I said earlier, for this perspective here today, as I mentioned, it's an interesting way to look at this now, almost 2 years on from the adoption of GDPR. We're kind of going back to basics, but with the hindsight is 2020 view here of been there, done that. Right, so the reasoning is that, believe it or not, there's still some organizations who have not completed all or even some of this work. And in other instances, we may have all done the work to meet the May 2018 deadline, but haven't thought about it in a while. And as we all know, the California Consumers Protection Act, CCPA, is now in full swing and is the first of what will likely be many state laws, and dare we say, even a federal law here in the United States. So with that, how we're going to go about this is that Dorothy's going to talk to us and take your questions from her view as a lawyer and the business she does in this field. It will be a broad overview of the law, the pieces we should all be aware of and paying attention to. And then Wendy's going to back that up and talk about her experience in an implementation for her good size organization. And that should give you some tools to get GDPR implemented or updated and what to look for and to do going forward. So with that, we're going to start with Dorothy, and we're going to take this GDPR thing from this macro view. So go right ahead, Dorothy. Let's talk about this.
So good afternoon, everyone. My name is Dorothy Deng, and I've been working with association nonprofits for about 10 years by now. I would say that GDPR, which is today's focus, really changed the landscape in terms of privacy protection. So there's really the before GDPR and after GDPR. So just to give everybody a basic understanding of the evolution, in the US, we are somewhat still legally at the before GDPR legal landscape, but it is drastically changing, especially given California law. So just a sort of understanding of the before GDPR. 3 things: say what you do what you say, and opportunity not to participate. That is before GDPR. Today, we'll talk about GDPR, which has become the modern privacy protection gold standard principle. So they are very high bar to meet, but if you start to think about how to get there, you are on the road to compliance, and that will only help you. But let's,
We'd be moving slides along. I'm sorry.
yes. But so today, my presentation will cover 3 things. Number 1, which you'll see on the slide here, is a territorial scope. This is the number 1 step for analyzing whether or not your organization is subject to the GDPR. So legally, do you need to comply with the GDPR to begin with? And I would say, based on my practice working with associations, this is the number 1 thing and the top issue that all of us should think about as step number 1. So that is the first topic. Second topic is, what exactly is your legal obligation? There's really 2 significance. 1, if your organization is indeed subject to the GDPR, you need to know what exactly is the legal obligation. If your organization is not legally subject to the GDPR, then the legal obligation would guide you because they are the best practice, even if you're not legally obligated to be upheld to that legal standard. It is still the goal to reach. Number 3, we will cover some practical recommendations, especially looking back 2 years, what we can do to, again, back to the theme, walk toward the road of compliance. So let's get right into the territorial scope. So for US-based associations, there are going to be 2 options. There are 2 ways that you can become subject to the GDPR. And the golden guidance, the Bible of how you would look into the detailed interpretation, is on the top link here on the presentation. So these are the guidelines published by the European Data Protection Board, the EDPB. This organization, they are the official guidance agency based in the EU. They have various guidelines guiding association as to how to do things. They're very detailed. They're a little bit funny to read. It's very European based. So sometimes you need to spend some time to understand it, but I would strongly recommend this territorial scope guidelines if you're not sure about whether or not the GDPR applies to your organization. But in short, there's really 2 ways. The number 1 is establishment. The number 2 here is targeting. So one of the 2 you need to think about when you come to your first analysis. So establishment, that is under Article 3.1. The bottom line is, if your organization has an establishment in the EU, such as a legally incorporated entity, which I believe is in Wendy's organization, that is the case. So I'm sure in the audience, there's some organization, you're very global, you have multiple global offices. If you have a legally building, let's say a lease, office lease with a number of staff located in the EU country, then you have absolutely an establishment in the EU. But the majority of associations may not have such a clear, defined, incorporated entity formed in the EU country. So that is when you need to consider, okay, what does the word establishment mean? If you have an EU chapter, does that mean you have an establishment? If you have some EU members, does that mean you have an establishment? Sometimes you have events in EU countries. Does that mean you have an establishment? So the guidelines actually explain how does the EU view what kind of activity would amount to an establishment. So for associations, the question to ask, and the key here, is the connection must be real and effective, and it needs to be through stable arrangements. For example, if you have employees in the EU, that's been working for you for 10 years, that would be considered more of a stable arrangement. However, if you have a consultant for a one-time project and that's it, and it was maybe a 2-week thing, it just happened that the consultant lives in Belgium, well, then maybe it may not be considered a stable arrangement because it is a one-time thing. So I'm explaining more of the extreme, but think about these things, whether or not you're even subject to the GDPR. So number one, establishment. Number two, if you do not have a establishment, another option for you to get into the GDPR scope is if you're targeting the EU market. And based on the guidelines, the EU authority is looking at your organization's intention. So how do you show intention? In the guidelines, the EU authority give a number of factors where they would consider, based on these website information, their domain name as such, they would demonstrate that your organization has an intention of targeting the EU market. And only if that's the case, then you will be subject to GDPR. So in my role, the number one thing when client comes to me and asks, do we need to comply with the GDPR? So typically, if your organization, for example, is a US trade association and your work is about US healthcare system and you do a lot of lobbying in the healthcare space, these are just hypothetical, it will be unlikely, and your members are all US healthcare providers, it will be unlikely that you would need to subject to the GDPR because everything is strictly US focused. Sometimes it is not as clear, so this is when we need to look at the factors that is presented in the guidelines. So it's very helpful. And just a side note, if your organization is clearly targeting the EU market, but you do not have an establishment, GDPR does require that you designate a representative to act as the person in charge of protecting personal data. So let's speak GDPR because, like I said earlier, GDPR principle has become the modern gold standard. So I'm sure we're all familiar with the term controller. What does controller mean? What does processor mean? What I want to focus on this slide, which I think is the most relevant to association, is the definition of consent. What is consent? Look at the bold type. Consent means the data subject must be freely given, specific, informed, unambiguous indication of their wish, and then they need to provide clear affirmative action. So what does that mean? And I think Wendy will get into that even more. But I think it's very interesting when you look at the legal definition of consent. It's most relevant in your checkboxes these days for association. When attendees go and register for an event, we must strongly recommend that everything is opt-in checkbox. So that is, why is that? Because once you collect the checkbox, the data subjects are giving you clear affirmative action. So that is really the way as your organization to protect yourself, because you can prove that I indeed obtained clear affirmative action by asking people to check the checkbox and allowing them the opportunity to review the privacy policy and also explain to them the purpose of collecting the very specific personal data. A second issue, which we're all very familiar these days, is the cookie banners. So the cookie banner in the GDPR, it doesn't really talk about it, but I'm sure we all remember when the GDPR just become effective, all of the websites start to have the cookie banners. And it really goes back to what is consent. So it has to be
people need to give you consent before you start collecting their information. So when you go to a website, that's why the first thing that comes up is a cookie banner. There are a few things, I mean, there are cookie banners all over the place now, but really, if you want to be upheld to the GDPR standard, if it is single okay, that may not be, that may not do the job. That might be okay in the US regime, but if you are strictly talking about GDPR, just a single okay, just a single accept, without any meaningful way to opt out, may not be sufficient for GDPR purposes. So then there's other terminology. I want to make a point about data protection officer because it has a statutory meaning. So if your organization actually does not process, monitor a large amount of personal data, you could consider designating a data a privacy manager instead of a DPO, because once you are calling yourself a DPO, it has a statutory meaning. So moving on, what exactly is your GDPR legal obligation? So the top thing is all of the processing must be lawful. In the association world, there are the most relevant ones. So you must meet one of the 6 in the statute. The most relevant one for association is number 1, consent, as we mentioned earlier. Number 2 is if you're performing a contract. So that would be if people sign up to be your member, if people sign up to attend your conferences, you have a contract. So that's another legitimate ground. Number 3, that is most relevant to association, is the legitimate interest. So that one is a little bit dangerous. And what's strongly recommended is because it's dangerous because it's flexible. So there's plus and minuses. But the recommendation is to go through an analysis, and you're better off documenting your analysis when such decision is made. So it is a 3-part test. Number 1, what's the purpose? Number 2, how necessary it is. And number 3 is the balancing. So as an organization, the way to protect your organization is to demonstrate that you've actually done the analysis if the collection of data is not by consent, not by contract, or if you want to use the data exceeding the scope of what people give you consent for. A common thing that I've seen is demographic information. So, or even more things that go into even further for diversity and inclusion purposes. So many organizations are interested in using this type of information, but they may not have diligently explain it up front, but they still want to use it. So this is when it's critical to document internally to make sure you actually went through this analysis before you go ahead and use the data. So back to the big picture here. The beauty of the GDPR and the dangerous thing about it is the GDPR does not tell you what document or what privacy policy or whatever the various policy you need to have. They don't say anything about it. Your legal obligation is, in this bullet point, you need to take into the account of the nature, the scope, the context, and the risk of likelihood of infringing on people's freedom and rights, and to implement appropriate technical and organizational measures. That is your obligation. And everything you do must demonstrate compliance. So moving on to the next slide. This is my favorite GDPR Article 5. And ladies, this is your closet rule. It's consistent, all right? Especially data minimization, okay? Garment minimization and storage limitation. All right, do you need your prom shoes from the 90s? You do not need your prom shoes. You need to throw it away. And Wendy's gonna mention that 2 years later, you have to review what you have. All right, ladies, 2 years later, look at your closet. If you do not need that piece of garment, throw it away. You do not need that. So I think it's just sort of life consistency.
I think it's the same thing for us guys with our t-shirts from high school, right? Same thing will go for you too, guys.
You do not need that. And every time you go to the store, what is the purpose? If you do not need that piece of another sweater, there's no need to obtain the sweater. It's only going to make your closet too tight and just too congested. Not necessary. Minimization, that is key. So these are actually spelled out exactly the way it is in Article 5 of the GDPR. It actually spells out the principles, and you are looking at the modern day privacy protection principle on this slide. So that's why I love Article 5.1. Take a look. It's just very self-explanatory, especially the ones in bold. So with that, we're looking at GDPR almost 2-year anniversary. Article 5, those are the principles to always keep in mind, even if you're not subject to GDPR. Number 2, in the US, there are many states that are going to follow the GDPR. Mostly they're focusing on the right to opt out and also notice to people. Notice the data subject, the purpose, why are we processing our information. So these are, if you want more information, I provided the link. There's actually a chart as to tracking the current status and what are the key features in this legislation. So the next point, and Wendy will cover this more, is what can we do at this point? So data mapping and gap analysis, that's always step number 1. If you haven't done it for GDPR, it's never too late, especially going forward. Number 2, based on the result of your mapping, you develop and implement key appropriate policies. There's no golden rule, but it's what's appropriate for your organization. Other things would be if every time you engage with a vendor, do your due diligence, especially your top data processors. And then on that point is to manage your contractual obligations. Look at do you have obligation with your collaborating partners, the vendors, your exhibitors, your sponsors? Is anything in your contract that talks about data sharing? It's very common in our industry. So you must abide by what you promised other people you did. And then the final point, very important, explore the cybersecurity insurance options if you have not done so. And then here I included some links which I find to be very informative and contain a lot of information, so please check them out.
So all great information. Thank you, Dorothy. We had one question come in. Now I think it's quick enough that maybe we'll just throw it in right here. Sharon asked, when you were talking about establishment in the EU, her question was, what if you have a volunteer, like especially a board member, somebody who's in your chain of command, as it were? Is that establishment as well that you had this member there?
So I would say go to the guidelines, but one of the key factor is this revenue generating? Does the processing gives your organization a lot of revenue? So if it's just a board member, if that is the only single connection you have, I would lean toward no, or at least take such position if this is the only thing. My concern for that question is, why do you have a board member in the EU? Are you targeting the EU market? Because most of the time, the board is the leadership of the organization. Usually, especially US-based organization, when they start to have board members that are from international space, that indicates their intent to target a specific area. So that could be interpreted, if not for establishment, potentially the targeting prong of the analysis. So, I'm sort of giving the lawyerly answer here, is even if you're not establishment, the intention is even broader,
Sure.
Especially if it's a board seat.
Got it. Okay. let's turn to how in the world do we do this, Wendy? This is, I know we're 2 years on almost, but again, there's still some folks in the world who haven't taken this on, or they took it on enough to say, I'm not really affected by this, which is a lot of what people did with CCPA as well, California's act. So get into this with us. Talk about how you planned and how you implement, and any suggestions you might have for folks.
Sure. We have done a planning and implementation at the Regulatory Affairs Professional Society. So that's what I'm going to share our steps to become compliant in this plan. So the first and foremost important thing is to create a full project plan around preparing for GDPR compliance. And what we did was create a plan, for example, in Smartsheets or one of your favorite project planning softwares. Of course, as Dorothy mentioned, the very first part is learning about the GDPR law and how it relates to your organization and your responsibilities for compliance. Once you have a good understanding of that, then you're going to do some milestone step-throughs. So one of the things we did during the initial preparation was we worked with our legal firm, and we worked with a data privacy lawyer there to come in and talk to us about the laws and how it applied to us as an organization. And at RAPS, for example, we do have an incorporation now in Europe, so we definitely had to become compliant in our group. So I'm just going to go through the milestones that we stepped through and how we did the implementation. So milestone 1 was a gap analysis. This is where your data mapping occurs. The first thing we did was held a GDPR workshop for all staff to teach them about our responsibilities as an organization. When you get all staff on board to understand your responsibilities, it's a lot easier to then put policies in place because they'll understand why you're doing it. And then the second part we did was created a GDPR task force. So these were key staff members who got together and discussed these policies that we had to put in place, how we put them in place. And key players were groups from marketing. We had staff from our education department, our membership department, all of those key groups that touch members. After that, we identified all of our vendors, the data they collect, contracts, policies, and procedures, and we put together a questionnaire for our staff, actually, and for some of the vendors. So it helped us determine what types of data our vendors were working with and also how we were sending them data back and forth. That helped us identify through the vendors their role as a controller or processor to RAPS. If they're a processor, they're processing information on our behalf. If they're a controller, then we're literally giving them information to then do a service of their own. So we were able to go through and assign all of those vendors as a controller or processor. This does take a little bit of time because you'll quickly realize how many contracts you have in your group, but it's a very important step to go through. And then the other thing we did was to survey our own staff to identify how they were handling user data. Everything from having a piece of paper of an incoming registration form sitting on their desk. Do they leave it there overnight? Does it have credit card information and address information? And then what are you doing with that after you process that registration? And then from that, it taught us things that we had to put in place in policies in our own organization to become compliant. And that actually was very helpful to us, even if we weren't doing GDPR, because it taught us to be better secure with the data that we were handling for our customers. And then at the end, of course, you're going to review that analysis and that gap analysis results to identify the gaps. Where are the vendors? What do we not have in place with them that helps us protect our data? what are staff doing that isn't secure? And that also starts to craft those policies that you need to put into place. So milestone 2 is taking that full analysis and creating a compliance roadmap. You're going to want to develop an organizational privacy policy. A lot of organizations have these already. It's probably not going to be enough. The privacy policy needs to be specific, as Dorothy mentioned, and it needs to clearly state how you're using that data, where you're sending that data to, and specifically what types of data you're working with. And in addition to that, for your organization overall, you're going to want to create a data protection policy. Now that policy identifies everything from if I'm sending something in an email, where is that email sent? Am I sending information to personal accounts? Maybe I have a staff member working on the weekend that's sending something to their Gmail account I don't know about. So those are all protection policies that you're going to want to put in place, and also make sure that you identify all of the individual pieces of data in that and how they're handled. And then finally, data protection agreement. And however many policies you need is based on your needs for GDPR, how in depth you need to go with these policies. For us, we created a data protection agreement. This agreement tells vendors and staff and controllers how we protect our information and how we handle that information. And that helps our staff and our vendors completely understand our stance as reps. So that then goes into developing additional policies. So what are these additional policies? And these are based on really your organization. You can put a lot of this inside of your data protection policy, or you can create something separate. We decided to do something a little separate so we could make sure it was well spelled out. For example, we created a data retention policy that 2 or 3 years or 7 years for financial data. What does that look like to us? And then what is our erasure policy inside of that? Data request policy. What we do when a user comes to us and says, I want to be forgotten. What are the steps that we take to make that happen? That's what the data request policy does. And then the data breach policy. What happens when we actually do have a breach? What are the levels of a breach? For example, somebody has a list of members on their desktop, on their laptop, they leave it on a train. Guess what? That's a breach. And you might not think about it, but it could be a breach. So what do you do at those different levels of severity? And then how do you respond to each one of those? And having that spelled out makes it really easy for your organization to quickly respond to those. And the quickness of response is something very important to GDPR. You're also going to go through and develop that very important opt-out language based on the type of data that you're collecting and what you're using it for. We have multiple opt-out language pieces, and we did bucket them a little bit, and it helped us to understand what we were using that data for. So membership is a contract. So you definitely want that opt-out language to be specific, concise, and very complete. You're just somebody coming in to create a profile to buy something. You're still collecting data from them. So you're going to want that to have its own data privacy opt-out. Event registrations. You might be sending their information to the sponsors of the event. You have to tell them that so that they have the choice to say, no, I don't really want to do that. Lead generations in associations, it's our bread and butter. We use it all the time. So again, being very specific in those policies is critical. And then, of course, once you've created your policies, you're going to want to get your legal review of your policies. This makes sure that you write it correctly so you don't get your association in trouble,
Yeah.
basically. And then creating governance for those new policies. And some form of keeping the governance in a common area where all staff and all vendors have quick access to it. You're going to identify amendments for contracts required from vendors and business partners, and you're going to start crafting your messaging to inform your users of how you're handling their data. So milestone 3, implementation. You're going to again hold another GDPR implementation workshop, showing them your new policies, showing them what you're going to want to do, and you're going to implement those changes. You're going to implement your opt-out wording across your technology boards. This also includes paper forms, so a lot of people don't think about that. If I have a registration form on the website and I'm asking people to opt in, I want it on that paper form too. Sending that messaging to users, explaining your stance on privacy. Implementing policies for data handling and compliance, notifying your vendors, and amending your staff onboarding and offboarding procedures. Now, those are things sometimes we forget. When a staff leaves, we want to make sure they're not walking away with any of our data. And we also want to make sure that they respect the data from the organization. Staff onboarding, GDPR, if you are compliant, has to be part of that onboarding process. You have to have a moment where you're training them on your policies and explaining it to them. So now that we've gotten through our milestones, everybody's compliant now. Congratulations. We all are very happy about that.
Yes.
So what happens after you become compliant? Well, you don't become complacent is the important thing. You're always going to review and document what all of your policies are. You're going to reconduct a gap analysis on a yearly basis at minimum, because you're always going to want to make sure staff are continuing to handle your policies as they should, as is your vendors, and as is all of your data storage areas. You're going to re-review implementations for compliance. Maybe you need to make some adjustments here and there. And you're going to re-review your documentation and create some permanent placements for those policies. So it's a never-ending story. You're going to want to be mindful of it at all times, just like you would securing your own home. You're going to want to lock that door before you leave, because you're going to want to make sure your home is safe. That's the same thing with compliance and association.
Great analogy there at the end. So I do have a few questions here, some of which are my own and some of which came through the folks here online listening. So I'm going to start with the last one first, because it more went to what you were talking about, Wendy. So Doug asked, give an example of, excuse me, a vendor that represented a controller versus a processor. So you've gone out and you've got these people doing things with you, have your data. Which ones would you suggest are processors versus the controller?
So for our sake, some of those were hotels, for example. When you're doing a conference and you're sending their registration over and making their hotel reservation, that is a controller to controller situation, because they're signing a contract with you simply to pass your data to them. Once it's theirs, it's theirs. So then the privacy becomes their responsibility. It is important, though, to note that if at one point your customer comes back to you and says, I want to be forgotten and I want to make sure everybody you've sent my stuff to gets forgotten, you do have to know where you're sending that data to.
Yeah. Did you want to follow up on that?
Well, I think the right to be forgotten is something very fashionable term, especially when the GDPR just came out. One thing to note, to keep in mind, is go back to the 6 lawful grounds in one of the slides. Your processing must meet one of the 6. So just because when someone says, forget about me, but they want to be remembered, Well, there's a contract obligation you have, and in order to honor your side of the contract obligation, you can't forget about your member, otherwise then you can't get it both ways. So these are the things that, you know, withdrawing consent for processing for demographic thing is different from someone buying a book and doesn't give you their credit card number. You cannot do that. So there's a lot of, that is why you have a data subject request policy to spell it out. And when it gets murky, you will need to seek legal analysis. Hopefully it doesn't get there. So hopefully the purpose of having a policy upfront is the staff, after training, can follow the guidance and steps. So step one, someone says, forget about me. Step two, do they have a contract? Or are they simply checking box for our newsletter? Right, that's a different purpose.
Sure.
So a good policy would clearly explain to the appropriate staff, when you receive such data subject requests, what do you do?
Right.
So that's just to tag on.
Right. So then a follow-up question to that was, which you've led right to, so I'm going to go ahead and ask this one too. So Christopher asked, how far down the rabbit hole do organizations have to go when data delete requests come through? So where it goes to financial transactions, as you said, forum posts where somebody's put something in the public, and then he goes on to ask about, you know, publicly available information as well. How far, you know, let's start over here with Dorothy. How far down that rabbit hole do I got to go dig up backups of data from 19 whatever and get rid of that person there?
So that is an excellent question, by the way, because that is a question
Gold star,
everybody is asking yourself. So, and this is back to the framework. That's why I think keeping to the basic is very important. Number one, are we talking GDPR or are we talking about US regime? So the legally, are you obligated to do that? That's number one. So if we're talking about GDPR, it's a little more complicated because of the entire GDPR shebang, right? If your organization is not legally subject to the GDPR, you're talking about a US regime. So the things that the baseline is, CAN spam act, that's a more common one. So if someone signs up for your newsletter and newsletter goes out, you are legally required in the US to have an opt-out mechanism. This has been in place for a very long time, so you need to honor it. So if I click unsubscribe, you have to actually honor my unsubscribe request. This is the US. So at the minimum, you'll have to do that. And that generally would take care of some issues that you just mentioned. If we're talking about, this is where we need to be careful, because your organizational policy, you want to be covering as much as you can, but you should only, especially if you are not subject to GDPR, you need to be careful about telling people what you can actually do. So if your organization's technology simply cannot track information that is posted 5 years ago, you cannot promise to people that you're going to scrub things in the past 10 years because it is technically impossible. And if you say something in your policy and you do not live up to what you promise people, you're going to be in a bigger problem. So the recommendation would be legally minimize your promise, but comply with your legal obligation. So there's a legal obligation. That's the floor you must meet, such as unsubscribe. And then there's things you aspire to do, but never overpromise.
That's kind of like what you said earlier about say what you're going to do and then do what you're going to say, right?
Which is a U.S. legal regime.
Right. Okay. So Wendy, quick question. Do you have components? Do you have chapters or anything in your organization?
We do.
Okay. So there was a question here about what to do with chapters. That here you have, I know in our organization at ASIS International, we have 200 and some odd chapters, and they come to us wanting data from us about their members as well. Tell us a little bit about what you did with your organization and how you handled that with your components.
Yeah, so in our membership contract or our membership opt-in, we actually make a mention of them being added to their local chapter. We also do that in the profile area because we allow people to be parts of chapters just by signing up in a profile. So that lets us get that opt-in for the chapter data, and we make it clear that we do share with the chapter if they request it. However, you also want to make sure your chapter leaders are aware of that data privacy, what they can do with that data, because they don't really think about maybe passing it on to a company, for example. If you haven't told your members that they're going to do that, you really shouldn't do that. So it's really important to inform your chapter leaders.
Do you have your chapters, have you, I don't know, maybe just talk to them about them creating their own GDPR program, however, you know, small that might be or large that it might be?
We have not on the chapter level specifically. A lot of it is just based on individual use at this time. So we haven't necessarily had them create their own policies. They typically fall under our umbrella in our case.
This is a great question. I hadn't even thought to ask this one. So here we go. Pete wants to know, have we heard of any examples of any US-based associations or even companies that have yet to suffer, his words, not mine, suffer consequences under GDPR? Has there been any examples of nonprofits yet who've been smacked around from this thing?
As far as I know, for our clients, not yet.
Okay.
Other than people upset, members being upset to getting emails from someone they suspect, that when I sign up for conference A, all of a sudden I start getting emails. That is probably the most common consequence, which is, then we've also seen associations where someone writes to the associations like, I want to exercise my right to be forgotten. That is also common. But in our business, more likely than not, if you're US-based associations, it's everybody think they're somewhat entitled to the GDPR, even if you are not an EU resident. Right. So,
even if you live in Amarillo, Texas, where I'm from.
So everybody feels empowered and entitled to a degree and tries to, and now there's a lot of awareness. So the times have changed. So that would be, I would say, the top trend that I've seen is awareness and people just becoming very alarmed when they start getting emails that they didn't believe they signed up, and they think it must be you who's sharing information without my consent.
Interesting that you say that. When I was at Internet Society, we had a large group of people who would create individual email addresses for everything they signed up for. So they would have, you know, Todd.Talbert +sign ISOC, so they know that they handed it to me, they handed it to the Internet Society, and if I get an email from somewhere else, I know where I gave that off. So it's interesting that you say that people are coming back around.
Right, and so back to what you can do legally. My recommendation to address that precise issue, which I see the most, is make sure in your privacy policy, the external one that you post on your website, that's usually the place people really want to start with, how we share data. That is the most important section for associations, because you want to be transparent and specific enough to tell people what you're doing. That being said, especially if you're not subject to GDPR, you want to give yourself enough flexibility to do what you do, but also point to the fact that, hey, I actually spelled that out in our privacy policy, so you're on notice to a degree. It may not be good enough under the GDPR scrutiny, but currently in the US, it is still consistent with being transparent and generally allowing people the opportunity to opt out because of the can spend unsubscribe mechanism. So it's all tying together, but the key is to disclose it as specific as you can, but make sure you absolutely need to be carefully vetting the how we share information section in your privacy policy.
So Wendy, another question here. so does an association need to get separate, so in the implementation, need to get separate express permission for every separate member offering? Or can the permission simply be to receive information about your news and your member benefits and all that? Can you blanket your, I guess the way I look at it is, can you blanket your relationship with one opt-in?
So you're going to want to bucket, and this is one way we handle things. Membership opt-in is one bucket. It's a contract. But what we also did in our marketing messaging was we bucketed things into education information, news, upcoming events, and then we honor each one of those buckets. So the messages that we send out also honors those buckets. So it allows somebody to opt out of something that they may not be interested in, but maybe they still want to receive information about your annual conference just because they're not interested in your books. So by bucketing those and also clearly knowing and honoring where you're sending that data to and what you're doing with it. So those policies are really important to create so that your staff also follow the use of that data for that policy. So that's how we handled it. So we ended up with probably about 15 to 20 different opt-out messages based on what they're doing with us. So events, news, lead generation forms, maybe you're even just doing a survey or a poll. What am I doing with that kind of information? So each one of those helped us identify buckets, and luckily we haven't added it on very many since we created those nice buckets.
Okay. So last question we're going to take today. So Gregory says that we're a solely US-based nonprofit medical education offering foundation. That's a mouthful, Greg. With 6 employees, I assume all of which are in the US. 10 website registrants, we have 10 with European email addresses. Does GDPR apply?
So here's my lawyer language, right? Based on the information that Todd just shared with me, I would take the position that the GDPR does not appear to apply based on the territorial scope analysis and go through establishment prong and the targeting prong. So the establishment prong we're looking at, back to the stage, is there some chance or really more of a marginal situation? The data to me sounds like it's more minority is maybe not of your activity. And also, is there revenue generating situation here, which I doubt it based on the description. So do your establishment prong exercise and do your targeting prong, which if this is a US organization, no .eu domain, no EU number, no European language on the website, mostly directing toward, let's say, medical type lobbying activity, advocacy, information geared toward US hospitals, patient, etc. Target is the US, your audience is the US. So do some kind of analysis and take that position, yet aspire to have something in place to aspire to do as best as you can. That's my recommendation.
Yeah, and I think, as we talked about, as Dorothy talked about, GDPR was the first one that kind of put a model out there. California and CCPA has happened. There's talk every day about a US-based federal law on this. More states are going to follow. So thank you both. Dorothy, Wendy, thank you for sharing with us today. We do apologize for the audio problems there at the beginning. We'll learn from that and make sure things are better as we go forward. Thank you all. We're going to post these slides and collaborate. We'll get those out there for you so that you can have those handy links and all that. Thank you all, everybody. Have a great day, and we'll see you around on the internet. Thanks.